All right, welcome back to Inside the Law. I'm your host, Philip Holloway. I wanted to take a few minutes. This is a special episode here because I want to take just a few minutes to talk about the appeal from the conviction last week in the New York prosecution of former President Donald Trump. In order to fully understand sort of what the unusual steps are that I think might need to be taken, it's first important to understand the way things ordinarily work. So, the first thing that you do is you have a trial, and then if there's a conviction after a sentencing, then you can file what's called a notice of appeal. And when you take a criminal case up on appeal, you have to argue all of the reasons that you think the trial court should be reversed, why you think your conviction should be overturned. You're going to have lots of different bases for that. You're going to say, well, the judge made this mistake, he made that mistake. There was lack of due process for this reason and that reason. So you want to put all of your legal reasons in the appeal so that it can all be addressed. And so when you're in the state system, here we're talking about the state of New York, you go first through the state appeals system normally. And in New York, that would be the appellate division. So you put your appeal together. Once the court gets the record together, and that's the entire transcripts, you've got all of the evidence, you've got the transcripts, you've got everything that happened. All of that has to be transmitted to the appeals court. And obviously, for a long trial, it can take a long time just to prepare the transcripts. So once the entire record goes up, the parties submit their briefs, there might be oral argument, and then you're going to have the appeals decision. Okay. In every criminal case, you have one appeal of right. And by that, I mean, automatically you have a right to appeal the case one level. So in this case, it's up to the appellate division, which is the mid-level court in New York. Believe it or not, the trial court is called the Supreme Court. The highest court in the state is called the Court of Appeals. Anyway, in the middle, we have the appellate division. Okay, so you have a right to get the case to the appellate division. If the appellate division affirms the conviction, in other words, if you take your case up and you lose that first round, you have the right to ask the highest court in the state, in this case, the Court of Appeals, to accept your appeal. It's discretionary. And then let's say you lose again. Let's say they take your case and you lose again in the highest court in the state. Then you have the right to petition to the Supreme Court of the United States. Again, it's discretionary. And by the way, they take very, very, very few of the appeals that they are asked to take that come from the highest court of each of the states. You have to have some federal basis of jurisdiction as well. So if you argue that there's a federal constitutional violation or some other federal issue at stake, then the Supreme Court may have jurisdiction, but they still have to agree that it's an important enough case for them to take it. Okay. So that's what we call the direct appeal process. Now, there's another type of appeal that we call the collateral attack. And what that is once you finish your state level appeals, if you still want to further appeal your conviction, you can file what's called a petition for habeas corpus relief in the federal district court. That's the trial court in the federal system. And of course, you then have to also allege, some federal jurisdiction there. And then you start over in a trial court. Okay. There's no jury. It's not like you're having another trial, but you do have a judge, and it's the federal district court. You ask that judge to reverse your conviction. If you lose there, or even if you win, the other side could appeal it. So that can go from the federal trial court level to the U.S. Court of Appeals level. And from there, if you want to appeal from that, again, there's another potential discretionary appeal up to the U.S. Supreme Court. Now, that's a very simplified overview of the direct appeal through the state system that could wind up in the Supreme Court. And then we've got the collateral or parallel attack over in the federal system. If you You see this typically in like death penalty cases where, the appeals go on and on and on. They last forever, 10, 15 years. Well, this is why, because you get these long appeals that take forever and they go through multiple levels, and then they switch over and they go through the federal habeas system as well. All right. So that's how it typically works. There's been lots of discussion on social media about why can't the Supreme Court just go ahead and do something? Why can't they just do something? Why can't they intervene? And in that regard, let me share with you. This is something that I posted on Twitter, and it got a lot of response from people. And I felt like I should maybe expand upon this a little bit. So, what I posted was that SCOTUS cannot simply intervene. That's not how it works. Well, it works the way I just told you in most cases, right? You've got to have the appeal that is brought to the Supreme Court, and it's brought to the Supreme Court in some appropriate legal vehicle. I went on to say in the thread that I'm seeing lots of comments and replies that argue that SCOTUS will, quote, intervene, or some words to that effect. Well, for the reasons I just went over, the Supreme Court of the United States must have a case properly brought to it. It cannot act on its own. Now, there are some creative long shot theories that are floating around on how to get it up to the Supreme Court so that they can act quickly. And let's just switch over and take a look at one of those. We've got Mark Levin. Okay. Mark Levin has posted the other day, he's thinking out loud. He says, the issue is how to get out of the New York system and bring the case to the Supreme Court, which may or may not take it up. That is why I look to Bush versus Gore, where the Supreme Court decided to step in because it was a presidential election. There was another court involved, the Florida Supreme Court, and it was that court that the Supreme Court believed was violating the Equal Protection Clause. That was the doctrine it settled on, given the unequal treatment of voters. So we're probably talking about semantics here, but when he says that the Supreme Court decided to, quote, step in, well, that's not exactly how I would have put it, because as he correctly points out, there was another court involved, the Florida Supreme Court, and the Florida Supreme Court had made a ruling, and it said there's going to be, we're going to do more recounts and all this, and we're in the middle of a presidential election, and the Bush campaign brought the issue to the Supreme Court. So it's not like the Supreme Court intervened. It's the Supreme Court ruled on something that was properly brought to it. And it was an appeal, a discretionary appeal brought from the highest court in the state, in this case, Florida. And so it was taken up on this discretionary appeal to the U.S. Supreme Court. They decided to take it. And of course, the ruling is what it is. And it was all done rather quickly because of the timing, because there was, we were in the middle of an election dispute here. But again, this was an appeals process that played itself out really quickly. But it was still an appeal directly from the highest court in the state of Florida. So Mark Levin goes on to point out, in New York, you would file the notice of appeal, ask for a stay of the trial court, and seek expedited review. And he's right. He's right about that, because one of the things that you're going to do once you're sentenced, okay, is you're going to want to get relief from that sentence. You want that sentence perhaps to be stayed. You want the Court of Appeals or the appellate division to order that your sentence be stayed. So what does this mean in the context of the Trump case? So we were talking the other day, look, you've got possibly jail. Obviously, there's a great reason you want to stay that. You don't want your client in jail. And if your client happens to be the nominee for the president of the United States for one of the major parties, you, of course, need to have your candidate able to campaign and do all the things that are attendant to that candidacy. And also, if your candidate wins, then he can't be the president from jail. So there's a lot of practical reasons you would want to have a stay of that sentence. Now, the way that works is the lawyers simply go to a judge on the Court of Appeals, or the appellate division, I should say, in New York, and they ask for an appeal bond. Okay, they may not get it, but if, let's assuming they can find a judge that is amenable and says, look, I agree that we need to hit the pause button on this sentence until we can fully develop and fully litigate the issues and the merits of the appeal. We're going to go ahead and issue this stay or do an appeal bond or something along those lines. And once the sentence is paused or stayed, then the appeals process becomes lots less frantic. The urgency kind of goes away, because if there's no sentence that's going to be served, even if it's probation, because probation or house arrest, those types of sentences also they infringe on the liberty of the accused. And in this case, we've got the presidential election, which affects all people in America, and of course, it impacts on the federal system of government. So there's a lot of reasons why you don't want the personal liberty of the candidate, the nominee, or potentially the new president-elect. There's a lot of reasons why you don't want to have the personal liberties of that individual subject to the whims of a probation officer or even a judge in the state court or any other court. So you want to seek a stay. Now, I just don't know how you're going to get the entire case on the merits of the appeal. In other words, when I say on the merits, I'm talking about asking for my conviction to be reversed because the judge committed reversible error. Okay. That takes a long time to properly frame and to litigate. And again, you've got to have transcripts and briefing and all these things that have to take place before a court can rule on it. So if the appellate division of the New York State appeals process says, well, we're not going to stay and we're not going to hit the pause button on this, what can we do next? Well, I want to go back to my particular Twitter thread here. Here we go. As I mentioned, the Supreme Court has to have a case properly brought to it. It can't act on its own. Bush versus Gore is not an intervention by SCOTUS. I've covered that. So if the state appeals court, the appellate division in New York, if they refuse to do an appeal bond or otherwise to enter an order that stays the sentence from taking effect in this case, the only remotely possible way that I can see is through what we call the emergency docket of the Supreme Court of the United States, usually used for things like a petition to stay an execution or to lift the injunction of a lower court. And even in those cases, there generally has been lots of litigation through the lower courts. These cases are brought to the Supreme Court. It could be by a state or a party to a lawsuit or a person who's lost a criminal case, in the lower courts. And they're now asking the Supreme Court to block the lower court order while the case proceeds through the appeals process. One example that I remember seeing in this case was during the COVID era. We had some state of New York had some rules that said, you couldn't participate, you couldn't go to synagogue, you couldn't go to church under, lots of circumstances. And there was an injunction sought in the federal court seeking to enjoin the governor, Cuomo at the time, from enforcing those rules. And that injunction was wound up being appealed, and it went all the way to the Supreme Court. And they used this emergency docket so that they could issue a quick ruling. And the thing you need to know about the emergency docket is that you need to understand that there's usually no order. Okay, there's briefing, but there's no oral argument, and there's usually no written order that explains it. Now, that's not always true, and of course, the court can deviate from those rules if they want to. But in any event, the mechanism that I can see that is at least plausible, even if it's a long shot, would be the emergency docket. So I want to let's see. I want to see if I can pull up some examples of what this emergency docket, and I'll go to SCOTUS blog, and they have a some example of some. These are not all the things, but these are, there you can see there's an application pending here that has to do with the congressional maps in South Carolina and whether the Supreme Court should grant a stay of the district court. Again, that's the trial court. So see, we've had some litigation at the lower court level in the federal system. And you see previously they have some things that are decided. Landry versus Calais, whether the Supreme Court should stay a district court. That's a federal trial court. Whether the Supreme Court should stay the injunction and allow Louisiana to use its new congressional maps for 2024. And then we see something like down here, and here's a death penalty issue, whether the Supreme Court should stay an execution of Brian Dorsey, emergency application denied on April 9th. See, this is an example of where the Supreme Court, this is going to be at the completion of the long drawn out federal habeas appeal process. So at the end, you get lots of different efforts at stays of execution on lots of different separate legal grounds, and you keep fighting for your client's life, literally, until either one of two things happens, until the execution gets stayed or the execution gets carried out. And so these are just some examples of how this so-called emergency, sometimes called the shadow docket, plays out. We have lots of just questions like whether Peter Navarro has met his burden to establish entitlement to release pending appeal under the Bail Reform Act. And that was an application for release pending on appeal denied March 18th. So, this is kind of what I'm saying. This is where they're trying to use this emergency docket to get some interim relief from a criminal imprisonment, if you will, and they're using this emergency docket for that purpose. Again, it's very, very unusual. See, even that Navarro case, that was a federal case. We were already in the federal system, and so they asked a district judge, and then they asked the Court of Appeals. Everybody said no, so they made a last-ditch effort to get the Supreme Court to step in using the emergency docket because it's not ready for what we call a merits determination, which is the traditional Supreme Court cases that we see argued. And, we're waiting on the what's called the decision in the immunity right now. We're waiting on that with the Supreme Court to determine the contours, if any, of presidential immunity. And so this so-called shadow docket or emergency docket is potentially one of the ways that the lawyers for President Trump can get his case brought before the Supreme Court. And they're not going to be able, because it's just not possible. I know that a lot of people are hoping otherwise, but you can't adjudicate and litigate the merits of your appeal in that length of time. But what you can do is you can try to get relief, temporary relief, from the imposition of the sentence or having the sentence against the client carried out. And you basically want to ask the Supreme Court on an emergency basis, hit the pause button. And I think that in this case, you've got a strong argument for that because you've got the federal elections, you've got the presidency itself hangs in the balance. You've got the rights of millions and millions of Americans who want to exercise their right to vote for, the candidate of their choice. And so there are very significant, I think, federal issues that would give the Supreme Court the hook that it needs to be able to take jurisdiction in this case. Now, it's extremely unusual, if not unheard of, for a trial in a criminal case to be concluded and have that issue immediately brought before the Supreme Court. It's, in fact, I dare say it's ever happened. Okay. Particularly when we're talking about an appeal from a state system. If this were a federal trial and you asked a federal judge for to stay the imposition of the sentence, go ahead and announce the sentence if you want, but before the sentence takes effect, let it be stayed so that we can, appeal these things. If the district trial judge says no, then you got the federal court of appeals, and then just one step after that is the U.S. Supreme Court. But the U.S. Supreme Court is so far removed from a state and local criminal trial court. There's just too many steps involved. I think the best you can hope for with them is to get them to enter an order that hits that pause button and stops the sentence from taking effect. So in any event, that's what I was getting at with this Twitter thread, and I got so many questions about it. People were like, "What what explain this? What exactly are you talking about?" And what I mentioned here in the very end of this is seeking to stay enforcement of a state trial court sentence would be unusual in the extreme, but of course, everything about this case has been unusual in the extreme. And with that, thank you for listening. I wanted to just take a few minutes to explain this. We're going to do more. I tried to do this live, had internet problems. So in any event, I hope this answers some of those questions, and I look forward to seeing you back here the next time we are live inside the law.